Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will discuss about a particular case which is regarding the unjustifiable dismissal.
Yeah, unfair dismissal.
Unfair dismissal of a philatist trainer. So, could you explain about the background story first, please?
Yeah. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. Yeah. The other day, one client visited this labor law firm and asked her case. She has been working as trainer in fitness club, but last July, she was informed about some termination. So she thought about only the severance pay, but they haven't paid the severance pay. Usually severance pay should be settled before 2 weeks after the termination, but she explained how to get the severance pay from the fitness club. So I asked her how she was terminated. Then she explained her employer asked her to stop working there, and she didn't submit the letter of resignation. Also, she didn't receive a written notification for termination. So, but she just accepted, and she didn't say anything. Only what she wanted is to receive a severance pay. So I explained to her, severance pay is a matter of course. In any situation, she is entitled to severance pay. Since she worked for that fitness club for 1 year and 6 months, so she is entitled to 1 month and half month salary for severance pay. But now she was fired unfairly, so she needed to take a remedy claim to the Labor Commission. That is what she can apply for the more compensation. So I explained to her and she accepted. So then whether she is eligible for this remedy application for unfair dismissal. So I asked her how she worked there as a fitness trainer. So she told me she received 1 million won as base pay, and based on a number of clients she trained, she received the incentive. So her average wage was 30 million Korean won. So okay, it seems to me she worked there on fixed hours, also based on fixed base pay. So she's like employee. Then I asked her how many people were there in the fitness club. So she told me there are 4 full-time workers, and also there are 5 more part-time workers. So I explained to her how the part-time worker worked there. So today work as freelancer, and today work as hourly wage, the part-time employee. So that means they freelance, part-time employee received based on fixed salary for each hour, or they received their salary based on their amount they taught to their client. So that means client paid the trainee fee, then based on that they divide the fee between them and the fitness club. So if they received such a portion of their contribution, not the base hourly pay, then they are more like freelancers. So, but if they receive the money based on each hour they taught, then they are more like employees. So I explained this the employee. Yeah.
I think more and more there are many employer who may take advantage of the labor law.
Mm-hmm.
So instead of employing more than 5 people, they just employ full time, like less than 5.
Yeah, that's right.
So this is a kind of a sensitive issue. So So did you explain in more detail about what you should
Yeah,
do?
yeah. So in order to be eligible for the like application for unfair, like maybe unfair dismissal claim, so there should be the company that hire the 5 workers or more. So in this fitness club, there are only 4, but there are 5 the part-time workers. So I asked her to check and know how those part-time workers worked there. Also, I asked her whether she worked as freelancer or employee. So she told me she has a fixed pay. Also, she has the designated working hours from 2 p.m. to 9 p.m. So then I explained to her, okay, it seemed to me it is very strong case. You know, to be very the qualified dismissal, employee should inform termination based on the written notification. Without the written notification, it is regarded as unfair dismissal. So.
I see. So did she follow your advice and she's going to do accordingly so that she can?
Yes, yeah. I think she agreed, pursuing for the unpaid severance pay is very small amount, but taking some the unfair dismissal claim look like more bigger cases. So she decided she could take this dismissal case rather than the simple the unpaid severance pay case. Yeah.
I see. So do you want to add any additional comment about this?
Yeah, so to be a justifiable dismissal or termination, employer should pay attention. Like written notification is very important. When employer want to terminate the employment contract, they need to receive a letter of resignation from the target employee, or they must issue written notification for that termination. So it also the termination notice must include the reason for termination and effective date. So then this notification letter is available. So without such a notification, even though there is a reason for termination or they satisfied all legal requirements, but still it is regarded as unfair dismissal because they violated the legally required procedure like a written notification.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.